Please do.
He's running business. I got jobs in Texas here later. He started out with us. That's a good line out of it.
Yes, there is.
It's really nice. Yeah, no, he didn't. Josh, here, I sent it to
Cheers.
because I sent it so that they have it ready to go. I sent it to Lena.
I don't know where that 134 house
Yeah.
If you want to speak tonight, we have another sheet for you to sign, which is over here by the computer.
I might need an early exit. I don't know. Yeah, I figured that's probably for best. I'm just going to do inside? No, inside. Oh, that's we did.
I could probably get you.
I don't need permission to sit where I want to sit.
Yes, that's okay.
Do I?
Yes, I signed you up.
Thank you.
That we have the option.
Throw for a loop and sign up to talk about the radio antennas.
Times of 1832. I call this meeting to order. Will the clerk please call the roll?
Mr. Anderson? Mr. Ello?
Present.
Mr. Randall?
Here.
Mr. Roberts?
Here.
Mr. Wood?
Here. Thank you. Anyone wishing to testify in any public hearing must have witness register for that public hearing. Mr. Paul, is there any correspondence for the board other than the cases pending? No. Don't believe we had minutes. Do I have a motion to rearrange the docket? Hearing case 040-18-22, push forward 037-88-22. So moved. Second. Thank you, Mr. Wood and Mr. Roberts. Voice vote, all in favor, say aye. Aye. Motion carries. I call the case 037-18-22. The petitioner is the zoning administrator. Request amend the Champaign County zoning ordinance as follows. 1. Add new paragraph 6.1.4 A.3 regarding the right to farm resolution 3425. 2. Amend sections 6.1.4 C and D regarding wind farm tower height. 3. Revise paragraph 6.1.4 D7 regarding paragraph detection lighting system. Oh, wait. I do apologize. Case 040-80-22. Petitioner zoning administrator 3. Request amend the Champaign County
Need everybody to sign in.
follows. Add new paragraph 4.2.1 C.7 to provide that a private or commercial transmission and receiving tower, including antenna, over 100 feet in height, may be authorized with a special use permit in the Act 1 and Act 2 agriculture districts as a second principal use on the lot with electrical substation. Location is zoning time schedule for development as soon as possible. Anyone wishing to testify in this case must have the witness register by which you can solemnly swear that the evidence that you will present will be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Hall, would you like to tell us a little bit more about your question?
Okay, this is, we hope, a very simple text amendment. We're not proposing any new standards other than to allow towers more than 100 feet in height as a second principal use on substation sites. We got an inquiry from an electrical co-op that was going to build towers for their own management of their substations. At the same time, they were approached by a company wanting to lease towers as a means of providing better internet connection for rural areas. And so, literally, all this amendment does, in our rural districts, we're very prohibitive on multiple principal uses on a lot, but that's what we're proposing, is to allow towers more than 100 feet high on electrical substation sites in Act 1 and Act 2. That's all it is. There's already standard conditions for towers over 100 feet high. There's a few standard conditions for substations. I would anticipate that not many substations would have the greater yard requirements required for towers over 100 feet high. So, and again, at this point, we don't even know if they'll really be over 100 feet high. This is sort of a backstop text amendment. But the board should be prepared that there may be some waivers for these side and rear yards. Now, most substations are next to farmland, so hopefully that won't be an issue, but you can deal with that when you're presented with that. For right now, the proposal is simply to allow this as a second principal use.
Thank you, Mr. Hall. Is there any questions from the board?
Is the proposal also just to change the height to 120?
No, we're not changing that. We're keeping all of the existing tower requirements, which are that a tower 100 feet or less, I think, is by right, and over 100 feet is a special use. So, I'm glad you mentioned that, Larry. In these future cases, we would deal with two special use requests on the same property. Possibly one for a tower of more than 100 feet high, and the other, that tower as a second principal use.
I'm sorry, we can't hear you guys at all. Can you turn it up a little bit?
We can try to turn it up. Normally it's turned up as loud as it can without getting serious feedback, but we'll try to do better. Let us know if we're successful.
Hello. Is this going to be about as loud as it will be? Okay. Thank you. Any other questions from the board? Not seeing any, I'm going to open the witness registry. Mr. Mike Wilson. Would you like to go ahead and head over to the witness testimony microphone?
Actually, head over to that one there, it's by the computer. Yeah.
Mr. Wilson, your mic is on.
Correct.
Your mic is speaking into the mic. Also, tell us your full name and where you present. And start with your testimony.
Very good. My name is Mike Wilson. I'm representing Eastern Illini Electric Cooperative. We're based out of Paxton, but we do have 8 substations within Champaign County. And so these are the substations in question. Recently, the federal government had what was called the rural, what's your address? My home address? Work address. Either one. I'm representing Eastern Illini Electric Cooperative 330 West Ottawa, Paxton, Illinois, 61957. Thank you. Appreciate it. Thank you. So last year, the federal government had the Rural Digital Opportunity Fund, which is it's called RDOF, and that provided federal grant money to provide internet access to underserved areas, of which East Central Illinois has quite a few. The company that won the RDOF auction in our area is a company called Nextlink. So once we figure out that they won the auction, they have dollars they have to spend in East Central Illinois to upgrade internet infrastructure. We got in contact with them and realized that our substations are uniquely located kind of in nice spread out areas within the rural areas. And so that lined up well with what they wanted to do. So they approached us to say, hey, can we put monopoles up in your substation locations? It worked out really nice because we also are trying to do a metering project where we needed to put up poles in our substations for a radio communication system for our meters. As it turns out, the optimum height for wireless broadband internet is 120 feet, so that's why we're here right now. So basically what Nextlink would like to do is put up 120-foot poles within our substations, so we're going to grant them a small lease in our substation area. They'll put up a 120-foot pole for their internet system. Right below their internet equipment, we will have our radio equipment for our electric distribution system. So clearly I would encourage the community to pass this. Thank you.
Thank you, Mr. Wilson. Any questions from the board? Any questions for staff? John, would you remind me, again, if this is up to 100 feet, and they're asking for presumably 120 feet. So for each of the poles, like they would have to come back for variance, correct?
Well, I'll come back for a special use permit for a tower more than 100 feet high, and a special use permit for that second principal use on the substation property.
So just to clarify, from what I understand, we can already come and request a special use permit for a tower height above 100 feet, but in this case, it's a secondary use, since we'll have both our electric distribution system equipment and the internet equipment operating on the same pole.
Any other questions from the board? Would anyone like to cross-examine this witness? If so, please raise your hand. Seeing none. I do apologize. We do not have cross-examination on the text amendment, but we will have time for other testimony. At this point, thank you, Mr. Wilson.
Thank you very much, and especially thank you for moving this up on the agenda tonight.
Absolutely. Would anyone like to testify in this case? Not seeing any. Do I have a motion to close the witness registry for 040-AT-22? Thank you, Mr. Handel. Do I have a second? Thank you, Mr. Wood. Voice vote, all in favor, say aye. Aye. Opposed? Motion carries. How would the board like to proceed? Could you repeat that, Mr. Randall?
I move that we accept the preliminary draft of findings of fact and move to the findings of
have a second? Second. Thank you, Mr. Wood. All in favor, say aye.
Aye.
Motion carries. I'm going to be reading attachment E, page 10 of 11. Final determination. Pursuant to the authority granted by section 9.2 of the Champaign County zoning ordinance, the zoning board of appeals of Champaign County recommends that the zoning ordinance amendment requested in case 040-18-22 should be enacted or not be enacted by the county board in the form attached hereto. The foregoing is an accurate and complete record of the findings and the determination of the zoning board of appeals of Champaign County. Do I have a second?
Second.
Thank you, Mr. Roberts. Roll call vote, please.
Mr. Randall?
Yes.
Mr. Roberts?
Yes.
Mr. Wood?
Yes.
Mr. Anderson?
Yes.
Mr. Elwell?
Yes. Congratulations, Mr. Paul.
Mr. Wilson, we'll see you at the April 7th meeting.
Very good, thank you very much.
Mr. Paul, before I call case 037-18-22, would there be anything that you'd like to address the public?
Well, we've had lots of questions about how these particular changes came to the ZBA, and these were changes directed by the Environment and Land Use Committee of the County Board. Many folks have reviewed the memo that we included as an attachment. These are the things that ELUC asked us to change. There's no time limit on testimony at ZBA meetings. There's a lot of possible testimony here tonight. The few guidelines we do have on testimony is that it be relevant to the case at hand and that it not be redundant as much as possible. I know redundancy is sometimes difficult to sort out, and the board is generally very patient with that. But insofar as the board has 5 changes before it, ELUC could have sent more changes, but they didn't. My advice to the board is try to focus testimony on these 5 changes. And if, for example, someone thinks that the proportion for separation from a wind farm tower to a participating or non-participating dwelling, if that currently isn't enough, that's really not relevant here. It's a relevant complaint to make to the Environment and Land Use Committee of the County Board, and you can do that once each month. But they didn't see that as an issue, and my advice to this board is that that is not a relevant issue for you to take up. Now, it's your decision. If you want to listen to every comment people have, that's your call. But under the bylaw rules, I think you could limit it to just testimony that's specifically relevant to these 5 changes. That's the advice I would have.
Thank you, Mr. Paul. I call new case 037-18-22. Petitioner and zoning administrator request amend the Champaign County zoning ordinance as follows. 1. Add new paragraph 6.1.4A3 regarding the rights to reform resolution 3425. 2. Amend sections 6.1.4C and D regarding wind farm tower height. 3. Revise paragraph 6.1.4D7 regarding aircraft detection lighting system, ADLS. Number 4, add new section 6.1.4R to require conformance to the State of Illinois Agricultural Impact Mitigation Agreement. And 5, revise section 9 regarding client in this case must sign the witness register by which he solemnly swear that the evidence that he will present will be the truth, the whole truth, and nothing but the truth. Mr. Petitioner, would you like to go a little bit further into the request?
Sure. I was asked by the chair of ELUC in December, actually at the December ELUC meeting, it was suggested that the committee should review the wind farm standards. I knew that specifically there was interest in updating our ordinance to require the aircraft detection lighting systems, and I knew that there was interest to update the ordinance to allow the greater heights of towers that are currently part of wind farm development. I had just been planning to leave our wind farm tower height at 500 feet, and then any developer that actually didn't think we could get any more wind farms, but any future wind farm developer would have to then request a waiver to go more than 500 feet. But I know, for example, some members of ELUC are familiar with these taller towers with higher turbines that put out more output. They've actually spent some time around them, and they also knew that there was this trend towards taller towers, and they would rather that Champaign County's ordinance be up to date than behind the times and then having to deal with waivers for any wind farms that are proposed. Honestly, at that time, back in December, I hadn't heard any rumors about possible wind farms. So everyone has seen the memorandum that we gave to ELUC. We reviewed those things for other counties in Illinois. Typically, comparable counties, McLean is, we consider McLean to be a very comparable county. Sangamon is a comparable county. We included other counties. We did not include all the Illinois counties, obviously. And so ELUC gave us the direction for these changes. In regards to height, I know there's a lot of concern about maximum height. I would expect any wind farm that we see in the near future to have towers about the same height as the Sapphire Sky wind farm that's proposed in McLean County. Those are 590-foot tall towers. The reason I recommended no height limit is we don't know where the technology is going to go with wind farms. We don't know if we'll even see any more wind farms. But rather than having this incremental levering up on the height, in my mind, it makes sense just to eliminate that and see what the market wants, what the FAA will allow, and our separation. The wind farm towers get higher, the separation is going to grow. And so that's the thinking behind that. I'm not proposing to change that approach. I still think it's the best approach. But just for board members, in case you're reading all these comments and wondering, well, why are we doing this? If we were to adopt a maximum height, I wouldn't recommend anything under 699 feet. And so that's why I'm recommending no height. Let's just do away with it and deal with the wind farm towers as the technology and the industry proposes them. That's all I have to say.
Is there a FAA allow?
Can't hear you.
Is there a limit that the FAA allow?
I'm not aware of any limit. They have 3 height ranges for wind farm towers. They have a range 199 feet and below, 499 feet and below. Actually, I guess it's 4 ranges. 699 feet and then over that. At 699 feet is when they require the intermediate set of lights on the tower. At 499 feet is when they require the second light on top of the tower. But they don't actually have a limit. They review each proposal for the impacts on air traffic and make a decision. To the extent that they find any proposal is an obstruction to air traffic, they call it out as that, and the wind farm developer has to mitigate it somehow. So I'm sure there's a height beyond which they didn't, you just couldn't deal with the obstructions to air traffic, but I have no idea what that would be. And obviously, that depends on what the air traffic is in any given area. So,
I know that there were a number of questions and all the stuff that I read about decommissioning, and whether or not we are adequately funding that. We describe exactly how
We can't hear anything you're saying.
how we go through that process and how that gets updated on a regular basis.
in regards to decommissioning, Champaign County is generally criticized as being unreasonable for what they require because it's so much greater than what other counties require. We have one wind farm. They're in the process of converting their letter of credit to an escrow account. Right now in that escrow account, there's more than $3 million sitting there waiting for Champaign County if it ever needs to go against the escrow account. So I think we're doing a good job on keeping on track with decommissioning. ELUC has reviewed that amount. They review it every 3 years for the first 12 years of the wind farm life. After that, they review it every 2 years. We're going to begin moving into that every 2-year process, which is a process I hate, but it keeps ELUC up to date on the amount. So I think we're doing a good job.
So every few years that you go through this process, there's an appraisal process that you go through to determine the actual cost, and so it's upgraded at that point.
Yeah, we get a licensed engineer. We get a cost estimate by a licensed engineer, and I'm happy to say they use the same engineer, so it's consistent. It's actually gained in detail over the years. We review that, and we take into account both increases in construction cost as well as increases or decreases in salvage value. And so far, the developer has only ever had to deal with increases in cost and decreases in salvage value. And so we're now at over $3 million. And that's why many people think we just go overboard on what we require.
Any other questions from the board? Mr. Wood?
The agricultural impact mitigation agreement, can you talk a little bit about that, exactly how that works? I mean, is there anything that we give up by relying on that with respect to the
No, in fact, I mean, our requirements are very similar to the Illinois Department of Agriculture's requirements. We modeled them on that. And when we adopted our wind farm ordinance originally, there was no such thing as an AMA. It didn't exist. They've since come into existence. And as you know, we require those for solar farms. And so when ELUC said, well, why do we need to do to update our ordinance? That was an obvious choice. I think it makes our ordinance a little stronger because not only is now Champaign County enforcing that, but the Department of Agriculture enforces it. Most of those standards relate to the things you have to do during wind farm construction. The decommissioning requirements under AMA are actually much less restrictive than our own, so we're not gaining anything there. And even under AMA, the actual enforcement is left up to the local counties. But I think overall it does make our ordinance stronger and brings it in line with state requirements. We don't have to require compliance with AMA, but as a zoning administrator, it makes me feel more comfortable knowing that we have informed the bag that we can fall back on if we ever encounter a problem.
I know that the distances that you're putting in here are a little bit more
again, my view is that ELA considered that and they're happy with what we have. So until ELA tells me to change it, I'm not inclined to change it.
Mr. Anderson?
Someone tell me the height of the blade at the peak of its height. If it would fall over, what would it expect that to be?
Well, in our current wind farm, it's 492 feet to the tip of the blade. If the tower fell over, didn't crumple, but just fell completely over with a blade extended to the maximum, it would fall 492 feet from the base. We require a 1,000-foot setback for participating dwellings, 1,200-foot, this is with a 500-foot tall tower, well, even for a 492-foot tall tower. So, that's how that geometry would work out in the current system. The separation to the property line has to be 1.5 times the wind farm tower. So it's not even going to fall over the property line. No, a non-participating property line. Did I answer your question?
Has anyone done any research on the pattern of fall that the wind turbine takes when it's super wind blowing it over?
I've never seen any numbers for that. I've never heard of the wind farm tower falling over. I can't say that it hasn't happened.
And certainly due to hurricane or tornado, there's been some blown over.
Okay.
Any other questions from the board? All right, so I'm going to move to the witness register. Mr. Stephen Smith. Stephen R. Smith,
Yes.
would you like to come to the testimony microphone? Please state your full name and your address, and then you can continue with your testimony.
The microphone's already on, so you're all set when you're ready.
My name is Stephen R. Smith. I live at 454 County Road, 2400 East of Broadlands, Illinois. My concern is, and I'm against putting the windmill farms in, I have some serious concerns about it. My uncle has a wind farm near his home and farmland, so I know something about the issues I want to bring up. They have destroyed the roads in the area. They were blacktop, nice roads. They came in, they covered them with gravel and calcium chloride, which creates a lot of dust and rust vehicle bodies and frames out. They tried to make the county roads one way, which causes many accessibility problems in the area. The roads now have deep ditches with a safety hazard and steep. Heavy equipment broke down field drainage tiles, which they did not always repair, although they said they would. The windmills are a hazard for agricultural aircraft application of seed chemicals and fungicides. If they fly above them, the drift would be severe. And if they fly through them, it would be either dangerous or illegal. And can you imagine trying to dodge the prop blades on those towers while you're spraying chemicals? The windmills cause noise which is disturbing, and I have a friend's yard, when you sit out there to visit, you hear the whoop, 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 and the blades as they go around.
Mr. Smith, are you addressing the text amendments that we're looking at today? Or are you just complaining?
Well, there'd be a safety issue with the blades breaking, and also the shed ice and snow, so they need to, you know, they said they were talking about 1,000-foot setback or 1,200 from a house. In Livingston County, they have 6 times the height of the tower, or 3,250 feet, whichever is greater.
Mr. Smith, where you're focusing on the text amendments?
Yeah, they need to be set back farther from anything, and it should be from the property line, not the house itself. Because if you have like 1 acre yard or 2 acre yard, you sit out in your yard, you know, so it should be from the property line. And I think they should change it to at least 3,250 feet, which is the same as Livingston County. And I have actually personally seen a broken blade. You talked about that earlier, losing the tower or whatever. By Route 49 North, the blade was stuck in the ground about half of the length of the blade. It was very close to the house and right by 49, right by the highway. So it needs to be set back and, you know, farther from any of the houses and stuff. And also, the windmills cause like flashing, you know, like in your window. You're sitting there, and when a shadow goes by, it's like sitting there with a strobe light on. They were talking in his paperwork that they would put up.
We're focusing on the text amendment today, not any particular windmill. So if you can focus your testimony on these 5 points, I would really appreciate that.
Okay, well, I think they should at least put the change the setbacks, you know, for the distance from any kind of property line for non-participating members, increase that.
Thank you, sir. Any questions from the board? Thank you very much. Thank you, Mr. Smith.
May I address the board, please?
Your name, sir?
My name is Brian Armstrong. My address is 105 East Irving Park Road in Itasca, Illinois. I'm an attorney here representing quite a few of the people here, and I am going to offer evidence later, but I just want to stop something about here right now. Mr. Hall, the zoning administrator, is incorrect. That testimony regarding the text amendments is irrelevant. That's plainly contrary to the law. If you prohibit these witnesses from testifying to the text amendments that you are considering, that the board is considering, you're violating their due process rights. The board is not permitted to do that. So I would strongly encourage you.
Mr. Armstrong, you have misunderstood what I said. That is not at all what I said.
Okay, well, the chairman is attempting to prohibit the witness, attempted to prohibit the first witness, and if he continues to prohibit all the other witnesses.
He's not prohibiting. When you try to go into the testimony on the issues at hand.
Would you please let me finish? He attempted to prohibit the witness from testifying about the text amendment itself. That clearly is a violation of due process rights, and if that continues, I'm going to continue to assert my client's due process rights. So I would ask you to allow them to testify to the text amendments that the board is considering, because if not, I think you have a due process problem here. So with that, I'm going to allow you to proceed with calling all of the witnesses, and I would ask you to allow them to testify to the substance of the text amendments, which is the whole reason this hearing is occurring. Thank you.
Didn't hear you.
Thank you. Mr. William Boyer, the board. Please state your name and address.
My name is William also resides in St. Louis. To the Champaign County Zoning Board, my name is Kate Boyer, and our home is located at 525 County Road 2400 East, just north of Broadlands by 3 miles. I have lived in the Homer City Broadlands area for 40 plus years. I am very concerned about constructing wind turbines around our backyard. I am unable to attend tonight, so I am sending my comment to be read to the board. I am sure the knowledgeable commenters attending tonight will already be listing the myriad of reasons as to why many of us oppose this proposed wind farm. I won't list all the reasons in an effort to refrain from redundancy, but I am concerned for my health and for the health of my children. I suffer from temporal lobe epilepsy, and several of my children are on the autism spectrum. One of the main reasons we purchased an isolated country house was to bring relief to our health. Noise and flickering lights are major triggers for both my epileptic seizures and my children's autistic episodes. Moving to the peaceful country was such an amazing transformation of mental and physical health. These machines will absolutely disrupt the peace which we have sought for so long to attain. We thought we were choosing a place that would be a safe zone for our family, and such a force of towering metal fans is jeopardizing that security. The short-term gain from a wind farm is not worth the health of Champaign County and its residents. Please use sound reason and keep these machines away from our homes. Sincerely, Kate Boyer.
Thank you, Mr. Boyer. Any questions from the board? Any questions from staff? Thank you very much, sir.
Thank you.
Is it Mr. Dirk Rice? Please state your name and your address, sir. And continue with your testimony.
Dirk Rice, 1752 County Road, Enter, North Idaho. I'll do my best. Came prepared. I thought to address, the substance of what you were considering. I guess I'm not sure after Mr. Hall's statement that that's what you want, but anyway, I guess my first statement is regarding section 6.14C1 and 2, and it's related to the height of participating and non-participating residents. Recommendation are 2 times the height for participating residents, 2.4 for non-participating. I guess, my opinion, if you're non-participating, it should have been at least double what a participating resident would be. If not, I would say 3 times. So I guess if, all we're here to do is make recommendations to this board, I would recommend voting against that at this time. I do applaud the requiring the aircraft detection light system. And I don't know, incoming wind farms, how much they're going to want to do that. I understand it's an extra expense. I would really encourage in your documents, when you mention this, other counties, all the regulations they have as far as business setback and everything. I would strongly recommend that you look at those because, especially when you look at the counties that are more current, several of them have, in my mind, substantially more setback required than ours. In this day and age, I think the 2.4 feet is minimal. You're 600-foot tower, you're talking barely over a quarter mile. To me, that's almost negligible. You just as well let them that are right next to you. So I would strongly encourage, this board at this time to, vote down this, or at least recommend against what's been proposed here, because I don't think the setback requirements are anywhere close to what they need to be, given the current technology, given the size of the towers. I also think, I find kind of interesting that we call it zoning, but then we say we're just not going to limit the height of the towers. I think that's wrong. I think you got to have a limit on everything. I don't see how you can come in anything and say we're just not going to limit what you can do. I don't see how that's reasonable at all. So that's all I have.
Thank you, Mr. Rice. Is there any question from the board? From staff? Thank you, sir. Mr. Jack Richards?
I decline.
Thank you, sir. Ms. Sarah Hastings? Please state your full name and your address, and then proceed with your testimony.
My name is Sarah Hastings. I live at 1947 County Road, 1100 North, Sydney, Illinois. I have emailed these citations to the board, so if you have any questions about where my sources come from, it has been put in front of you or is available via email. Regarding case 37AT-22, amend 2B, amend 6.1.4D.5. I don't understand your reasoning in asking for an unlimited height restriction. According to the article cited in front of you, it says that a 300-foot wind turbine can throw debris 1,200 feet. I don't understand an unlimited height restriction almost has no setback available to ensure the safety of the residents of this county. My next point. According to the article, modern wind turbines generate dangerously dirty electricity. Wind turbines create, in addition to potential health problems, they interfere with radio, TV, satellite, and radar signal. What provisions is this board going to put in place to not interfere with the new broadband towers we just heard about? And I think you all heard about the tornado that went through Macon County and it disappeared from radar because of the wind turbine interference on their property, and it just popped up. How are we going to protect the residents of this county from tornadoes, which are a real potential threat to our livelihood? According to the article at Forbes.com, which is in your email, court cases have demonstrated that property values decreased 22 to 55% if a wind turbine is on their property or near their property. How is the zoning board going to go about lowering the assessed value for homes in the footprint of this project or near this project? And how is this decrease in tax revenue going to be accounted for whenever this money goes missing?
Amen. Amen.
Finish, thank you.
Any questions from the board? Staff? Thank you, Ms. Hastings. Is that Kurt Allen? Please state your name and your address, sir.
Thank you, Chairman. In that regard, I did see an agenda for the meeting, so maybe you could clarify for me. Right now is oral testimony, correct?
There is testimony for this case.
Okay. Are you having a separate public comment?
That's what this meeting is.
Okay. If this qualifies as public comment time, the Attorney General has opined you cannot require people to provide their address.
This is actually not public comment, this is testimony in a public hearing.
Okay.
Chairman, public comment is a separate thing.
Chairman, if I may, and I apologize, sir, I don't know what your affiliation is here. I didn't hear the introductions to who you were counsel?
I don't know, sir, I'm not.
Okay, and that's why I asked my question. If this is testimony, I need to know, because I don't want to know when my public comment is, because there's two different things.
So, as I read earlier, anyone wishing to testify in this case must sign a witness registry by which you solemnly swear that the evidence that you will present will be the truth, the whole truth, and nothing but the truth. So help you God. So that is signing the witness registry.
You notice my name is on there. I didn't sign
That
it.
is correct.
And so is this my public comment period?
Mr. Allen, item 9 on the agenda, after all the cases, item 9 on the agenda is audience participation with respect to matters other than cases pending before the board.
Okay, so that answers my question. There is a separate public comment period. So you're saying during oral testimony you're going to require an address, correct?
That is correct.
Okay. And I will also provide public comment. This will be my oral testimony. My name is Kurt Allen. I reside at P.O. Box 593, Kansas, Illinois. For the members of this board, first off, I represent Edgar County Watchdogs. We're a 501c4 nonprofit local government accountability organization.
Can you please repeat the name of your organization for me?
Edgar County Watchdogs.
Thank you.
How many of the board members have actually read the zoning act in the county code? Show of hands. Ma'am, please.
You are going to show the due respect for the staff and for the board.
Oh, I totally respect her, but she's not the chairman. I'm asking a question. Do you choose to answer or not?
We don't have to answer the question.
So during a hearing, you don't have to answer any
You
questions?
are providing testimony, sir. You're not asking questions.
My testimony will ask you questions, and I am allowed to ask questions. Okay?
But the board does not have to answer your questions.
Duly noted. I appreciate that. That says a lot.
Go ahead, sir.
Section 5-12-001. This is right out of your county code. And I'm actually appalled that nobody can raise their hand and say they actually read this. Authority to regulate and restrict location and use of structures for the purpose of promoting the public health, safety, morals, comfort, general welfare, conserving the values of property throughout the county. I find it amazing that in this docket that was handed out, two of the most recent zoning ordinances, one out of Christian County, one out of Baker County, was not included. That had some of the most protective criteria focused on the value of property rights. I don't see anything that focuses on the value of property rights. I would hope that we go back to the basics, read the statute, and focus on exactly what the statute says we should be doing. That's all I have for my oral testimony. Does anyone have any questions of me?
Any questions from the board? For staff? Thank you, Mr. Allen.
Thank you. We'll see you in public comment.
How about that one?
That's you.
Mr. Armstrong?
I'll introduce myself again. My name is Brian Armstrong. I am an attorney with the law firm of Lucian's, Brady, Garner, Armstrong. My partner, Mr. Lucian's, and I represent a number of people, residents here tonight, and a number of people who also cannot be here tonight.
Mr. Armstrong, can you state your address?
Sure. Again, my business address is 105 East Irving Park Road in Itasca, Illinois, 60142.
Thank you, sir. Go ahead with your testimony.
complex issues with respect to wind farms and wind turbines. One of the biggest issues is noise, and that is directly related to one of the amendments, actually two of the amendments, the height amendment and the setback amendment. Some of you may know that the Illinois Pollution Control Board has regulations regarding how much sound can be emitted from one property to another property. We're not going to get into the details of all that, but suffice to say that residential property has the most protection as far as how much sound can be emitted onto residential property. And also, we also have different standards for sound that's emitted at night versus sound that's emitted during the day. For obvious reasons, we want it to be quiet at night. The regulations also provide that the limits apply to the entirety of someone's residential property. So, and property that's used for residential purposes. So you might have a 20-acre parcel of property, maybe you farm 10 acres of it, and you use 4 acres of it for residential purposes. Those 4 acres, the entirety of those 4 acres are protected against sound emissions that exceed the Pollution Control Board regulations. And those sound limits are measured at the boundaries of those properties. And this is all relevant because the size and the location and the setbacks of turbines all dictate the sound that's emitted to those properties and to those areas of properties. I have a number of exhibits that I'm going to submit, and for administrative purposes, I have paper copies that I can hand out to you today, but I also have them electronically. I'm happy to provide them however you prefer. So if you just let me know, I'll provide them however you prefer. Thank you, sir. One of the most respected acousticians in the field is Dr. Paul Gilmer. You may have, some of you may have heard of him. He's a PhD. He studied sound issues for probably 50 years or so. He's a University of Illinois graduate. He's testified in quite a few wind farm cases and also wind zoning amendments and the initial drafting of wind farm ordinances in Illinois and elsewhere. I will provide you some testimony that he has provided in other counties. And the Pollution Control Board, Illinois Pollution Control Board regulations, the sound limit on residential property, the most that a residential property can receive under the Pollution Control Board regulations is 45 decibels, basically. It's much more scientific than that, but for our purposes, we can use the number 45. Mr. Schomer was on the committee that helped draft those rules 50 to 60, I think it was 40 to 50 years ago. And he has testified repeatedly that those regulations should not apply to wind farms because wind farms didn't exist when they came up with those regulations, so they never contemplated the noise effects of wind farms and wind turbines. So since then, he's done a number of studies, and he's also reviewed other studies, and he's come to the conclusion that the highest level of sound emission onto residential property should be in the range of 38 to 39 decibels. And that's what he's testified to in McLean County and some other counties, that that's the appropriate level. And the way he came to that conclusion, as you explained, is that the sound that is emitted to property is measured by acousticians based on the annoyance level that it creates. And acousticians, when they talk about annoyance, they don't mean, someone's annoyed because their internet's out for an hour. That's not what the annoyance that acousticians talk about from sound is
disruption of your life, or difficulty in living, you can't sleep, it causes you headaches, those types of things that affect your health. And some of the things that I'm going to provide you are the studies that Dr. Schomer and another Dr. Munch rely on for that. There's a study called the Health Canada Study that you relies on, and that many other experts rely on. That concludes that annoyance begins at about 35 decibels. Dr. Schomer, nonetheless, concludes that 38, 39, that 40, that range is what's acceptable. And the basis for his conclusion that it's acceptable is that at 39 to 40 decibels, about 3 to 4% of the population who exceed that level suffer from this high annoyance level that is life disruptive. And he recognizes that it's impossible to get to zero because if you hear sound, you have the possibility of being annoyed by it. So at the level of 39 to 40 decibels, about 3 to 4% of people are going to be annoyed. He concludes that that's something that we can live with.
Mr. Anderson, or, sorry, Armstrong, are we referring to the tower height when we're talking about like the decibel and stuff like that?
Well, that gets into a complicated question because tower height affects the decibel level, the size of the blades affects the decibel level, the location of the tower of the turbine affects the decibels, how close multiple turbines are to one another affects the decibel levels. And really, the impact of towers and their locations and their size on particular properties can only be studied when you have an actual plan with turbine locations and you know the surrounding areas and how many turbines there are, how close they are, that sort of thing. Those are the types of engineering studies and sound studies that are submitted with an application for a special use permit to construct a wind farm.
So would that testimony then be appropriate when we have that in front of us, or with this text amendment?
It will be, but as I said earlier, it is relevant to the amendments that you're proposing, and I will get to that. Another physician, Dr. Jerry Punch, is another physician who studied the adverse health effects of sound from wind turbines on people who are on property that receive the sound. And I'll provide you with his materials. To briefly summarize, there are documented adverse health effects from sound from wind turbines. And one other quick item, somebody else mentioned this earlier, blade failure. Blade failure happens. Nobody knows when it's going to happen. Nobody knows how it's going to happen, where it's going to happen. But sometimes these blades break or explode, and then the pieces go flying. And nobody knows how far they're going to go. Nobody knows where they're going to land. Same thing with ice. Ice, there's ice throw. Ice throw is a common issue with blades. And again, nobody knows how far these ice chunks are going to go. Nobody knows where these ice chunks are going to land. Manufacturers of the turbines typically have some data on safe zones, how far away things should be from their turbines. Part of that is based on exactly these things, ice throw and blade failure, and how far they anticipate pieces will go flying. One example, there was evidence in the recent Christian Champaign application that ice throw up to 2,000 feet is possible. So the chunk of ice can travel up to 2,000 feet from the lake. So how is all this relevant to the amendments that are before you tonight? Obviously, tower height. The higher the tower, the bigger the blades, the more noise that is created, and the farther it will travel. And the
is the most practical way to mitigate these risks. Setbacks are squarely within the province and control of both the zoning boards recommend and the county boards approve. So these are things that you have control over. And I saw some things in your packet. You have a comparison of a bunch of different counties and what their rules are. Livingston County has a setback of, I believe it's 3,250 feet. Cal County has a setback that's 6 times the tower height. And so my recommendation is that you implement setbacks that are at least 3,250 feet from a residential structure, not 2,000 feet. That's not far enough. We already know that ice runs can travel 2,000 feet with ice flow. So 2,000 feet is not enough. 3,250 feet is our recommendation. That's not an arbitrary number, by the way. Again, going back to Dr. Schumer, his Dr. Punch, the evidence that approximately 3 to 4% of people will be highly annoyed at the distance of 3,250 feet. That's their conclusion. That's in the materials that I'll give you. Any closer, the level of annoyance is increased. The risk from these ice road and blade failure increases. And that's just the property. That's the up in the streets, cars driving down the street. There's always, when turbines are closer to the street than they are to a residential structure, obviously there's greater risk that people use the street. And then the last thing I want to comment on is there was some statements that there should be no height variation, or the recommendation for the amendment is to have no height variation on the turbines, towers. And I think the comment was that was the trend. Well, we've been involved in wind farm matters in 8 or 10 counties, and we have never, in any county, seen an ordinance that had no height variation of any kind. So you're breaking new ground. You're in uncharted territories. And frankly, to impose no limit, the reason the zoning board of appeals exists, the reason why the conditional use permit process exists, the variation process exists, is right there in the statute. Mr. Allen, I believe his name is, quoted, it's to protect the health, safety, and welfare of the public. So to impose no height limit at all is a complete and total application of your responsibility to the citizens of the county to evaluate and protect their health, safety, and welfare. So to suggest that there be no height limit at all is, in my opinion, completely improper. A special use process for a height, variance process, a waiver process, if an individual property owner wants to waive that, that's a different thing. But to impose no limit at all is a complete application of the board's responsibility. And finally, there was also some comment about what the ELOC committee wanted and what they asked for. The problem with that is you have to base your recommendations based on the evidence and testimony you hear tonight, not what the ELOC wants. Your obligation is to make your decision, make your recommendation on the evidence you hear from the public, not from what the ELOC wants. So with that, I'm going to conclude. Again, we think there should be a height limitation. The idea of having no height limitation, I think, is completely improper. And we recommend a setback distance of 3,250 feet. And I have, as I said, I have 7 or 8 exhibits, documents that I will give to whoever the proper person is to give to distribute. And I would ask you to review those items, especially the testimony of Dr. Schumer and the information from Dr. Punch, because that is directly relevant to the setback issues that are being considered. If anybody has any questions, I'm happy to hear them.
Any questions from the board?
is 2.4 times the tower height. So for a 600-foot tall tower, it would be 1,440 feet.
And one of the issues that you brought up was the fact that you can have things that are tossed further than that distance for that particular height.
Certainly, and as I said, the taller the turbine, the bigger the blades, the farther those things are going to go. And so, to have it tied to the tower, that's one of the reasons why most counties have at least some component of that. But again, you see in Cal County 6 times, that's the highest we've seen, but 2.4 is on the low side as well.
Mr. Armstrong, so if you take 3,200 that they you mentioned, correct? Correct. And then if you divide that by like 699 feet, which was like the third level of like what FAA would 699 feet. That would be a multiplier of 4.65.
Well, and understand, 3,200 feet is from a residential structure. And again, the board, if somebody asks for a variation, for a variance to reduce it, that's part of the reason why the zoning board appeals exists to make those recommendations. But 3,200 feet from a residential structure is a road.
And like, that would be any size?
Any size turbine, you mean? Yes, that's correct. Yeah.
So then there's no multiplier then?
Well,
or like our urban ELOC's recommendation of the multiplier.
well, if the multiplier was 6 and you had a 700-foot tower, that's 4,200 feet.
Correct. So like, I'm just trying to get your opinion on like if 2.4 is not enough, then is 4.6 enough?
Well, and we can do some math here.
Okay. And that's 3,200 divided by 699.
If you have a 500-foot tower, and you multiply it, shooting, obviously that's 1,500 feet. I can only do round numbers with math. If you have a 600-foot tower at 3, that's 1,800 feet. If you have a 700-foot tower at 3, that's 2,100 feet. My recommendation, again, for residential structures, 3,200 feet. If that turns out to be six times, other counties have done it, then I think it'll be appropriate.
So like a flat 3,200 in our multiplier then?
Well, if you're going to impose a multiplier, it has to be enough to address the issues that have been raised that were discussed before, with the ice throw and blades and the noise. So if the county, if the board is going to impose a multiplier, 2.4 isn't enough. It doesn't create a sufficient setback to protect safety. I can't tell the board what the correct number is, but I can tell the board that 2.4 is insufficient.
Curious, on smaller towers, do the blades spin faster than they do on taller ones?
You know, I'm not an engineer, I can't answer that. I only know that they probably appear to move faster, just like a small plane appears to be traveling a lot faster than a 747, but I think that's an optical illusion. But I'd have to defer to the answer and engineer on that.
Just curious, because if it spins faster, it's going to throw it further for a smaller tower than a larger tower. Just because of my perspective.
Any other questions from the board for this witness? Mr. Anderson?
Yes, earlier when you presented some acoustic, what frequency was that acoustic data you gave up?
Typically, the standard for these measurements is 1,000 hertz. Certainly, geography affects how the sound travels. Tree cover affects how sound travels. The distance of buildings. What time of year? It travels farther in the winter when there's snow on the ground and there's leaves on the trees. It travels farther. So that issue that you're asking about, that's the type of information that is typically included in a detailed application for a wind farm, and there's an evaluation that includes that information to determine what levels a particular building or a particular property receives, what sound levels that a particular property receives. It might be 41 decibels, it might be 38 decibels, maybe 45 decibels. So, but when you set an ordinance, an ordinance or follow the code or regulation, it sets the decibel level, and then it takes an average. It's like a weighted average over the course of an hour. It's very detailed. But when the studies are done, you see the numbers that are proposed in the application. Typically, if the study is done properly, they account for that. We've seen that where they don't account for that, and that's a problem because, as I said, sound travels differently in different areas depending on the obstructions and the terrain and the geography and the season of the year. So those types of things, when you get into the minutia, those types of things are things you examine when you're looking at an application.
But you know, as the people report bothersome, on the quiet night, the rhythm of the blade, or the whistle when you have a storm wind.
Yeah, well, different people suffer different consequences. Some people hear the hum or constant noise of the blades turning. Some people have testified that they actually feel it in their chests. And then another person was talking about it, sort of hard to describe, but you can imagine the oof, oof, oof of the blades turning. So, different people suffer different effects. The common one.
How do you account for that in the restriction? How do you account for individual differences of the noise of the people's hearing?
That's getting back to one of the exhibits, so that Dr. Schomer basically concludes that if you get down to 39 or 40 decibels, you're basically going to have the smallest number of people adversely affected without completely eliminating the wind farm. He doesn't say that nobody will be affected. He says that's how you get to the lowest percentage of people having adverse effects.
Thank you, Mr. Armstrong. Any other questions from the board?
John, isn't the requirements for already admitted in the zoning laws that they have to meet the standards of the pollution control board?
That's right.
Okay. So you might be suggesting that that's just not good enough.
Yeah, and look, I understand the sound levels are decibel levels. That's not a subject that's being considered to be amended here. So getting into the details of that might be more than we need to do. But my point is, as I said before, those things are affected by both the size and the setbacks, the location and the setbacks have a direct effect on those things. The bigger they are and the closer they are, the greater that effect. And setbacks and the size are the most practical ways to mitigate those adverse consequences.
Because the problem we have here is that we have so many other things that rely specifically just on that standard. There's so many different types of noises. This is something that is particularly unique, that needs a more definitive standard, or a better standard. I
Any other questions from the board? Scott? Thank you, sir.
Okay, and I have exhibits labeled LVGA 1 through 8. I'll give you paper copies for you to distribute as you see fit, and as I said, if you want electronic copies, I'm happy to provide those as well.
Thank you, sir. Mr. Harkey. Please state your full name and your address and present your testimony.
Good evening. I'm going to do as best as I can to talk in this microphone. It's very tough here in the back of the room. My name is Ted Parsky. My address is 1183 County Road, 2300 East, Sydney, Illinois. My previous address was 2121 East. I've forgotten it now. 2250 North Road, 50th, Illinois. And that was inside the Invenergy wind farm that was built in Vermilion in Champaign County. And can I go ahead and proceed? Okay. I'm exhibit number 9. Me personally right here. I'm exhibit 9. And I'm going to tell you what happened to my family. Okay? A wind company came to my community, and we were in favor of it. We thought it was going to be great. It was going to help my neighbor farmers financially. It was going to help my school. And everybody else here hear me okay? It was going to help my school, my kids. Everything was all set. It got approved. I worked for an engineering company. I did some surveying for the wind farm while it was developing. They built the project. Everything was still cool. As soon as they turned on the wind turbines, my wife and I and my kids couldn't sleep in our house any longer. We came and complained to county boards. We went to public meetings. The company Invenergy, they turned off the wind turbines 51 nights between January and May of 2013. They turned them off because they were trying to keep us at bay and keep us quiet. On Mother's Day of 2013, they refused to turn them off any longer. And that's when I really got the word out that these things are not good. So, by the fall, my wife and I had taken all the beds in our bedrooms, our kids' room and our bedroom, we put all the beds in the living room. And we lived in the living room, sleeping in there, until Christmas weekend when we moved out of our house because of sleep deprivation. We moved out of a perfectly wonderful house and we lived in a double-wide mobile home for a year and a half. After that, I found a home in Sydney. We moved there, and we've been there since. We've fixed up the house, and now we're finally happy again. It took from 2013 until 2022 for us to get back to where we were with a nice home, comfortable living, and back to what we had before. A lot of mentioning has been done about Dr. Paul Gilmer. Dr. Paul Gilmer lives in Champaign, and we tried to hire him in April of 2013. He could not work for us because he was already employed by Invenergy, the wind company. So, we asked him to do a noise study at our house because we weren't sleeping and we knew something was seriously wrong. He refused to help us because he was already engaged with Invenergy. Invenergy showed up in the fall after lots of pressure from us and a neighbor of ours. And they proceeded to hire a guy. And we said, we want you to hire Dr. Gilmer because he already works for you. He's from Champaign. It makes more sense to hire the local guy than the guy from Wisconsin. And Invenergy agreed to that. So Dr. Gilmer from Champaign did a partnership study at my house for 4 months. Started in August, September, October, November. So after he got done studying it for 4 months, he went several places. He went to Boone County, Illinois. He went to Livingston County, Illinois. And after working for Incompatible and studying the noise at my house, in Livingston County, he came up with a slide. Incompatible wanted to build 500-foot tall turbines there. And he had analyzed that project. One of his slides said he studied 220 homes, and 218 homes were protected, but 2 were still unprotected. On that slide is where the 3,250 feet came from. So here's a guy that studied noise at my house with 500-foot turbines. He analyzed the 500-foot tall turbine project in Livingston County, and he presented under testimony to their zoning board 3,250 feet. The Livingston County zoning board put in that standard distance and have a 500-foot tall turbine limit height based upon that testimony, because that's how they could avoid lawsuits from wind companies who wanted to say that they're too restricted. They had some evidence and some proof to fall back on to make themselves not susceptible for wind companies to challenge it, and it has not been challenged yet. Okay? Earlier we talked about what kind of noise and why it's bad or whatever. The reason why I believe that we left our home is not because we could hear it inside the house. We could hear it in the home. But it was how it would wake you up or keep you from sleeping. This is like a throbbing, thumping noise that you just, if you visited my house, it was not very perceptible. I had a lot of visitors come and tell me I was crazy and you're just a wuss. But when we try to sleep at night in our beds, the throbbing noise is inescapable. It comes inside your home. And it's because it's like a subwoofer bass noise. It thumps. It sounds like people opening car doors in the driveway and closing them. If you've ever not had your shirt on and someone comes to visit you and you hear a car door out in the driveway and you think, oh my gosh, I need to get a shirt on. That's the feeling of it all night. It sounded like your child falling out of bed in the middle of the night. It just jolts you awake. If you're trying to sleep, you just can't relax that last 5% in order to fall asleep. And we're talking about annoyance and how this affects people differently. It all really has to do with your position from the wind turbine. If you're downwind from it, you're going to feel that air pressure pulse. At nighttime, there's very little ground movement of air. And at nighttime, turbines mostly move because it's catching upper wind. So when the turbine blade gets vertical, it catches a hard breeze and it flexes a little bit. As it gets back down horizontal or lower, there's no wind there, and that blade will flex back. The blade flexing frontwards and backwards, there's 3 of them, that causes an air pressure pulse. That's why we have sleep deprivation in your wind turbines. Okay? If you visit one in the daytime, I'm telling you, I live next to them, and visiting in the daytime is nothing like trying to sleep next to them at nighttime. So this is the things that I want the county to have. I think the 500-foot tall turbine height limit is good, but I want it to be, that height limit needs to be at 3,250 feet. Because Dr. Gilmer measured it at my house, and he went to Livingston County, they used that number, and here's what's good about it. If you give people the chance to have a safe setback that they can sleep in their home, and the wind company says, we can't live with that distance, you're going to eliminate the wind farm. That's a false statement. What the 3250 does is it lets a homeowner, wherever they live, it lets them have the opportunity to discuss with the wind company how much noise that they want to tolerate, and how close they want the turbine to be next to their house. So if you put in a big setback like 3250 and allow all the waivers that you can imagine, a wind company can simply go to every homeowner and negotiate that distance that they want to come closer to their home. Those things are called good neighbor agreements, or you can call it an easement, or a noise abatement zone, or whatever you want to call it. At least people have the chance to do it. If you don't, and you allow turbines to be too close to people, what you do is you become the middleman. You become the middleman, you insert yourself, and you give away those rights for free. You give away the ability for children to sleep in their bedrooms at night, and you just hand it over to the wind company. If you put the safe setback in place, you empower the minority. Minorities are, the smallest minority is the individual. So if you let the individual, family, or homeowner decide for themselves, you let them handle that. You don't just jam it into their backyard. On the noise thing, we talked about the IPCB noise limits. The IPCB noise limits, to measure that, it's like nailing Jello to a tree. It's very difficult, it's very expensive, it takes a long time, and my wife and I and my neighbor, we spent about $15,000 hiring an acustician to come measure my noise levels. In energy, I think they spent about $200,000 doing a 4-month study, just to prove that they were under that noise limit. When the noise levels came out from those reports, Energy was 0.1 decibels below the maximum allowed noise level for nighttime noise. You can't expect or have a family stay and sleep in their house when the noise levels are at the maximum noise level allowed by the state of Illinois all the time, or 4 nights a week, or even 3 nights a week. It's impossible to raise a healthy family like that. I sent my kids to school, sleep deprived, they got bad grades. It was very hard on my marriage. I could go on and get pretty emotional here, but I'm going to save you from that. Over the years, I've become more controlled and more angry, and I'm able to tell you this story without breaking down. It was very difficult. When we talk about the current setback at 1,200 feet, that's absolutely pathetic. If you have the distance from the 500-foot turbine that we had next to our house, my house was at 1,665 feet away from the closest one, and the next closest was 2,225 feet away. Ford County put in a distance of 2,250, while my house was at 2,225. And they came up with that number because it was 25 feet further than my house. Because they knew, and I testified, and I told them what happened, and they felt that they could do that. And if you take my distance from my house, that is 2,225 feet away for a 500-foot tall turbine, you need about 4.5 times the height. And you'll get the exact same results that my house had. I think that you guys need to be 6 times or 6.5 times the height. Regardless of your current 1,200 feet. I want to talk about where 1,200 feet first came from. John wants to use this multiplier, 1,200 feet at a 500-foot tall turbine. He wants to have to use multiplier for everything getting bigger. I want to remind everybody here that a 1,200-foot setback came from when turbines were only 350 feet tall. So if you take a 1,200-foot multiplier from 350, you're going to come more closely to about 5 times higher. So this is like moving the goalpost all the time. We're trying to take something that already doesn't work and make it better by using the same standard. We need to start over. After my wife and I had major issues with energy and we left our home, Apex Wind Company was building a wind farm up near Hoopston and Rossville. The county board and the county assistant state's attorney told Apex, we don't want any of these problems like we had at the first wind farm. Apex had no problem. Apex went to every single home in the entire footprint of the wind farm, and they did a good neighbor agreement with every household within a half mile of the turbine. So the half mile comes into effect that if the wind company thinks a half mile is good for a 500-foot tall turbine, maybe that's where that distance needs to start, and the multiplier starts from that. There were 3 homes, 3 families in Apex Wind Farm in that same project. They refused to sign the good neighbor agreement. So what Apex did was they purchased those 3 houses. At the next meeting, so I'm going to bring some slides. I'm going to show you exactly what happened with 2 of those homes, how much they paid, and if they're buying houses a half mile away, and there's nothing wrong with wind turbines, doesn't it sound like Apex was protecting themselves because they know that there are problems within a half mile if they go ahead and purchase the house? I think they, when I was talking about getting waivers and letting families decide for themselves to choose if they want the turbine close to them or not, the ultimate waiver is when the wind company comes and buys your house from you. And I think that Champaign County citizens should be afforded the same thing that Apex offered in Vermillion County. That'd be totally fair. And for a family that has kids like I did, and they happen to live in the bullseye south of Sydney that's happening right now, if I was a young father, after living through what I did, I would tell people to sell out and get out of the way and take the money from the wind company and not go through what I did. It was terrible. So after I moved to Sydney, my house was still for sale for like another year and a half. My house was empty for 3 years. You take 3 years times my insurance, my mortgage payment, my taxes, I shelled out about $100,000 for the privilege of owning an empty house that was 2,225 feet downwind of turbine. Nobody came to my aid. I was on my own. It was a huge setback. I don't want anything like that to happen to my neighbors south of Sydney. I want to talk about some noise limits. One thing that was great that came out of the solar farm meetings, and I think I came to every single solar meeting. At every meeting, I brought charts and documents to show and prove and give evidence to the zoning board at the time that anything at 40 decibels or louder was going to cause sleep issues and noise complaints from neighbors next to solar panel inverters. The inverters make a buzzing noise, okay? And I asked the developer, and I asked him, what's the noise limit you need for solar? Because I've been told solar is so quiet, you'll never know they're there. He said 45 decibels at the property line. Well, adverse health effects begin at 40. So I'm asking, oh, I forgot a part. So I pounded on this, and the zoning board, and the ELEC committee, and the county board at the time, they didn't want to mess with the IPCP noise limits. And they said, we don't need to mess with that. We know it's bad for wind turbines, but for solar, we're going to keep the IPCP noise limits. That was mentioned a couple times by zoning board members, that we know turbines are bad, but the solar panels are not as impactful. So, when it came to the permit hearings, specifically for the particular solar project, I still came back and hammered on the noise level, and they gave a conditional use for that first solar farm that was approved over there. It's for the Baywall project. Their conditional use was they're going to keep them limited to 39 decibels. And the way that the solar company treats that is they put noise shelters over the top of their inverters, or they're going to put the inverters in the middle of the project. And I thought that was awesome. That's how these meetings should go. Decisions should be made upon information and proof that we can bring to you. And I'm asking the same thing for a wind turbine. Here's what's cool. If you put the wind turbine, they're 500 foot tall, 3,250 feet away, the noise level is just under 40 decibels. Okay? The staff here wants to limit our discussion to only height, multiplier, but they don't want to talk about noise. Well, what drives the height and multiplier in the distance is all about the noise for me and I think for everyone else. So I plan to come back here every night to have a hearing. I'm going to bring slides and documents and charts. I'm going to give you all of the backup data that you need so you don't have another Exhibit 9 like I am coming to zoning meetings, board meetings, and then testifying across the rest of the counties in Illinois that have wind farm meetings. I'm tired of going to those meetings. I don't want that to happen here with any people that spend a bunch of their time for the next 10 years feeling like they have to go help someone else because they got the shaft just like I did. Okay? I think I've said enough for this evening. I think I'm through, unless there's some questions.
Any questions from the board? Mr. Anderson.
Thank you for educating me. At your dismay and disappointment, you and your wife saved many hours of time. Thank you.
I don't know what to say to that response, but it's very hard to go places and get in a situation where you can't help people, and it's like a train wreck happening. And I'm very nervous that people won't take to heart what I have to say. I'm here to tell you what I'm telling you, the God honest truth. So thank you very much.
Thank you, Mr. Harvey.
Thank you. Have a good evening.
Didn't hear. Mr. Darrell Rice. Please state your name and your address.
Darrell Rice, address is 726 Kennedy Road, 1800 East, Violet. I certainly can't compete with Mr. Armstrong's legal expertise, nor some of the scientific path that you've heard from a couple of our witnesses, but I have a plea for you, and I do think I represent many, if not most, of the landowners and homeowners sitting behind me. I'm Darrell Rice. My wife and I, Regina, we live on the farm on 1800 East, just south of the line between Philo and City. We live on the sesquicentennial farm, which means it's been in our family for 150 years. The farmstead sits on an 80-acre tract, which was purchased by my great-great-grandfather in 1857. Many of my neighbors live on Centennial Farms, land in their families for over 100 years. Ours is a heritage of producing crops and raising families on family farms for generation after generation. We have a love for the land, and as stewards, desire to leave it in the best condition we can for generations to come. We are privileged to farm some of the most fertile ground in this country, and we do our best to feed our nation and indeed a significant portion of the rest of the world. It makes no sense to us to take ground in this part of the country out of production for a wind farm. We don't want to see it, we don't want to hear it, we don't want to farm around it, we don't want it near our homes or on our land. We built a house 2 years ago just down the road from the original farmstead in order to allow our son to sit in the back row here and his family to move into the farmhouse. It's a log home that my wife and I have been planning for over a decade. We intended to retire and live out our years on this property, but the idea of a wind farm right outside our window makes us think that we may have made a mistake. If this does indeed happen, we ask you to please place reasonable height limits on these turbines and increase the setbacks beyond what you are currently considering. It may be just another field to you, but to us, it's our home. Thank you.
Mr. Randall?
10 minutes.
I have a motion for a 10-minute break. We would be coming back at 20:30. Do I have a second? Thank you, Mr. Wood. Voice vote, all in favor, say aye. Aye. Motion carries.
Open days. Hey, Larry, how are you? Oh, just trying to be responsible. Trying to be responsible, really. Government. That's a change from school, isn't it? Right, right. You enjoying this weather the last couple of days? Oh, yeah. I've been out with my grandkids. It's been great. Yeah, the kids are like, I want to come inside. I want to come inside. I know.
Howdy, howdy.
Emptying my bladder. Yeah, they're taking advantage of the break. Hey, Larry. What's good, boys? Sorry about that. Hey, Steve.
It's that way, I'm pretty sure.
Six or hell yeah.
I see you coming up here.
I had an interesting comment to make. Is it? That's all right. You paid for this building, so it doesn't matter. It's all nobody else.
I can hear it.
Saturday. I know. I took the scout out the other day.
Benjamin Rice, live at 768 County Road 1800 East, Philo. I'm here representing the 6 generations to farm our family ground, and I've already raised the 7th generation. And as I get to see my 3-year-old and 1-year-old run around our 7-acre yard, I can only enjoy God's creation around me. And to think that something against my will, like a unlimited height wind turbine that could be put out too close to my yard, that not only would affect my family inside our house, but not taking into consideration the 7 acres that my kids get run around outside, and the noise coming from these, that we can't enjoy that, and then also the dangers of it, of watching these things break apart or throw in ice. I've always liked the idea of my county zoning department that is going to bat for my family and our rights and watching out for our land that we have. And some of this that's proposed tonight, I feel is going directly against that. And so I would just like to ask you guys to take into consideration how this would be affecting us. Already raising up the 7th generation, and if these things stand through the next 100 years, be affecting generations 8, 9, 10, and even more than that. So please take into consideration our rights out there.
and can enjoy the peace of life in the country and in a safe manner also. Thank you.
Thank you, Mr. Rice. Any questions from the board? Any questions from the side? Thank you, sir. Is it Mr. Stoughton? Brad? Stoughton? Could you please state your name and your address, sir?
Brad Stoughton, 664 County Road, 1800 East Sydney. Appreciate the opportunity to speak. I'll be brief. Got one page here. I'm a resident, not a farmer, just a resident. And let me start by saying that we all live in one of the most beautiful parts of Champaign County, where many of us here call home. We would like to preserve this for our kids and our grandkids. Many times wind farms get placed as a result of absentee landowners with little to no regard for those who call that area home. We're asking you to give us a say in this, give us a voice. In order to preserve what we have, I would request that serious consideration be given to increasing the required setbacks and limiting the turbine height. This proposal before you is entirely unacceptable. I encourage you to not pass this. Livingston County setbacks, tower heights seem entirely appropriate. I believe this is appropriate in our county as well. This could at least partially mitigate issues with sound, vibrations, shadow flicker. These are all legitimate issues. If you've not been down to our part of the county, I would encourage you to take a drive some of you. South of 501, left on 700 north or any of those east-west roads. And just take a look at this beautiful gift that God has given us. It's a true gem, especially in the evenings. It's just a fantastic area. It's a place we call home. This is our home. Please don't spoil it for us. Thank you.
Thank you. Mr. Ed Decker. Please step forward and state your name and your address, sir.
Sure. Hi. Ed Decker, 915 County Road, 1700 East Philo. First off, I'd like to thank you guys for your community service. I don't know what you get paid, but I know about community service. I'd like to thank you for that. Two things I'd like to address is the height and the setbacks. I think it's totally irresponsible to give it an unlimited height. I'm here actually tonight to keep it at 500 feet. Setbacks, I think the 3,250 has come up several times tonight. I think that's a reasonable setback. I also think that needs to be from each property line as well as each dwelling. My reason thinking on that is really like I've got a 30-acre tract south of Philo, and these leases are for 90 years, 50-year lease, 2 options for 20 years apiece, make it 90 years. Maybe my great-granddaughter or great-grandson wants to build a house on that 30 acres someday and make a dwelling out. Well, if my neighbors so choose to put a windmill right next to it, to keep it under the decibels, it would diminish the value of that 30 acres, and my great-granddaughter possibly couldn't build a house there. So respectfully, that's what I'm asking. Don't raise the height, just keep the setbacks up. And I guess, I'm not a guy that puts anything, if you give this 3,250 from every boundary, house, and everything, it's going to make it almost impossible for them to put a wind farm down there. I'm not going to beat around the bush, that's what I'm asking for. Any questions?
Any question from the board this time? Thank you, Mr. Decker.
Thank you.
Ms. Kelly Becker. Please state your name and your address.
Hello, everyone. Well, and thank you for your public service and for listening to the voice of your constituents. I know that's hard to do sometimes. My name is Kelly Better, and I'm representing Family Farm at 525 County Road, 2400, Broadlands, Illinois, 618. Okay? The first thing I was wanting to know, I just have a couple of questions. I hope you can answer them, because one of them was talked about tonight already. you said that the decommissioning and that you had put some money in escrow, like $3 million. Is that for each tower to be taken down or $3 million across the board?
It's for the entire wind farm.
Okay, and you said
So
that
they do answer questions.
you have an engineer, and the engineer is the same as, who's the engineer? The engineer you're using for the village, or the same engineer as the company?
I think what you're referencing is the fact that the decommissioning estimate has been prepared for the one wind farm we have. The decommissioning estimate since 2010 has been reviewed by the same engineer every time.
But it's your engineer, your personal engineer for the city? Who does the engineer belong to?
It's the engineer the wind farm hires to do that.
Okay. That's good. That sounds like a conflict of interest.
I asked the county board to pay for consultants to assist the county in the review of wind farms, and it was rejected. So we do the best we can with what we can.
Wow. Okay. That's interesting. Okay, so the other thing was, I want to know if you've done due diligence in finding out what other counties, maybe even out of our state, that have had long-term relationships with Apex. And I'm assuming it's Apex you're using, right? Because we only found out about this a few days ago. And
You know, this hearing is not about a wind farm.
oh, it's about ordinances for the wind farm, right?
Right.
Well, that is about a wind farm then.
No, it isn't. It's about a zoning ordinance requirement for wind farms.
Okay, so you're not in contract with anybody yet?
We're not in contract with anybody else.
When you're not, nobody in the city is in contract with these wind farms yet?
I can't speak for people in the city.
Just curious. I mean, well, it's a town, it's the county that would regulate that anyway. So you're just trying to make regulations. Well, in parting then, might I suggest, like you've done with other counties, do what other counties have done, and just make ordinances that prevents a wind farm from even coming in. That's all I got to say. It's easy to do, and we can do it. Thank you for your time.
Any questions from the board or staff? Thank you. Mr. Todd Horton. Please state your name and your address and proceed with your testimony.
My name is Todd Horton. I live at 1808 County Road 900 North, Philo, Illinois. I shared an email, sent that to the zoning department, and I believe Susan responded that it's been received. And I'm not going to read it to you verbatim, but I do want to talk about a couple things. Bottom line, the purpose of zoning ordinances everywhere is to prevent incompatible land use. Incompatible land use would be having, $1.5 million homes right next to the Clifford Jacobs Foundry in North Champaign. We don't do that, right? That would not be a good idea. Why is that? You might say, well, Clifford Jacobs, they're staying on their land, they're minding their own business. But if you've ever been outside the Clifford Jacobs Foundry, you know it's pretty dang noisy, isn't it? And that area up there, is that Wilbur Heights?
Yes.
Wilbur Heights, the property values are pretty low. Okay? Now, I am not going to try to conflate that with this. But what I am saying is what happens on any particular land in allowed use does affect people beyond the limits of that allowed use. There are several examples throughout the zoning ordinance. I was just researching one on light just the other day. We don't like flashing lights or flickering lights. It's in the sign ordinances. And the simplistic approach would be, say, well, it's on their land. They can do what they want. No.
I appreciate the comments of one of the early commenters this evening that said, you know, I've got family members that are subject to negative health effects with things like strobe lines. Yes, I have an adult son with disabilities who has seizure disorder. We have to be very careful about keeping him away from flickering lights, because that triggers, we have seen it, trigger seizures. Well, you know, I really am concerned that an incompatible land use would be something that creates flickering lights coming through the windows of our house. I'm not the only one who's concerned about this. You know, we heard from another commenter already this evening. I want to point out a couple of things in the existing zoning ordinance. And there is a section that, section 6.1.4, Wind Farm County Board Special Use Permit, and specifically paragraph M, standard conditions for shadow flicker. And before the question gets asked, this does pertain to tower height and setback distance. Thank you. The applicant shall submit the results of a study on potential shadow flicker. The shadow flicker study shall identify the locations of both summer and winter shadow flicker that may be caused by the project with an expected duration of 30 hours or more per year. Shadow flicker that exceeds the above standards shall be mitigated by any means such as landscaping, awnings, and fencing. I'll go ahead and read some of this because it's probably clear. On the surface, it appears that providing a study of shadow flicker during summer and winter conditions, as the standard says, would be sufficient to define the problem areas within and near the wind project site. The sun angle is high during the summer and low during the winter. However, this requirement ignores the sun conditions during half the year. You know, there are two other seasons besides summer and winter. You might think, well, Todd, those are extreme conditions. That's going to cover it. Not necessarily. Okay, this requirement ignores the sun conditions during half of the year. In other words, a property may be unaffected by shadow flicker during summer and winter, yet adversely affected during spring or fall. If the wind project developer merely satisfies the language of the ordinance as written, then their shadow flicker study will ignore the problem for half of the project's lifetime, spring and fall. Okay? Department of Energy, they have a website, and I've listed it in the document I provided for Susan. They state, computer models can accurately predict when, where, and to what degree this problem will occur. So wind project developers can mitigate this impact during the site selection process. Folks, it's a geometry problem. We can do 3D geometry extremely well these days with computer modeling. In addition, they say many local ordinances incorporate language addressing shadow flicker to minimize any potential impact on neighbors. Now, yes, the Champaign County zoning ordinance does address shadow flicker in the section I've cited, and that's it. And let me go on. That section places no obligation on the wind project developer beyond securing a study and providing screening materials close to the affected citizens. It doesn't say, our zoning ordinance, as it stands right now, does not require the developer to actually use the study for decision-making purposes. Get my point here? They can create the study and say, we checked the box. We have a study. Okay? I haven't been in construction contract enforcement, and I'm not the only one in the room that has a great deal of experience with this. I work for the federal and the state government, and trust me, there are plenty of folks out there that if the standards are loose enough, they will take advantage of that looseness.
And our county zoning ordinance is extremely loose. The language of 6.1.4 does not specifically require the wind project developer to consider shadow flicker in site selection. Okay? It can be treated as an afterthought according to the way the ordinance is written. Section 6.1.4 does not define to what extent the flicker is to be mitigated. It just says mitigated. Well, mitigate doesn't mean eliminate, it means reduce. Well, how much do we reduce it and call it good? Neither does the ordinance specify who will bear the cost of maintaining mitigation methods over the lifetime of the wind project. Thus, right now, as I see it, Champaign County has no authority to compel the wind project developer to offer any long-term solutions to shadow flicker. The section in the zoning ordinance that talks about shadow flicker, as I see it, is legally toothless. It's a boilerplate that says we have addressed shadow flicker, but it has no teeth. Stated simply, our ordinance does not require elimination of shadow flicker. It only requires the wind project developer to attempt a reduction, and it does not establish a criterion for successful mitigation. They can say, we tried. Like Ted, like Ted alluded to, they tried, and they got tired of trying. 51 nights, they turned it off, and they got tired of trying. So they were able to say, we attempted to mitigate it. But here, when it comes to shadow flicker, there is no standard for what is acceptable reduction of shadow flicker. So really, we've got acknowledgement that shadow flicker exists, but we don't have anything in our current zoning ordinance that has, it's really nothing that says it's enforceable other than they provide a study. It doesn't say they have to, the wind developer has to follow the study. So, let's see. Perhaps the simplest solution for shadow flicker is to temporarily immobilize appropriate turbines when the flickering is predicted to occur. Current methods in modeling shadows readily enable wind project developers to know exactly when and where flicker will affect nearby properties. It's a 3D geometry problem. It's not hard. The language of our current ordinance does not specify this as a method for eliminating flicker, but it should. This is a serious weakness of our current Champaign County zoning ordinance. Section 6.1.4 appears well-intentioned, but through its weak language, it favors the wind project developer over the citizens who live within the shadow flicker area. U.S. Department of Energy also states on the webpage cited above, the impact of shadow flicker from small wind turbines is minimal due to shorter heights and smaller rotor diameters. Logically, the converse is true. The impact of shadow flicker from larger wind turbines will no longer be minimal due to taller heights and larger rotor diameters. So as wind turbines grow taller, and I hope they don't, the shadow flicker issue will loom larger. Even if turbines don't get taller and they end up in southern Champaign County, the shadow flicker issue is not adequately addressed in the current zoning ordinance. It's a token section that mentions it, but it has no teeth. Champaign County's zoning ordinance in its current form needs careful modification to protect not only our current citizens, but also our future citizens from increased shadow flicker. Thank you for your very careful consideration. That's all I have.
Any questions?
My understanding that the turbines, depending on the wind direction, they actually change the way they face.
Well, yes, yeah. So flicker is going to be affected by certainly the wind direction, because that's going to rotate the entire head, okay, the entire turbine.
Time of day that it occurs.
Right, right. And certainly sun angle. So in the summer, got a high sun angle, so the shadow is not going to cast as far from the pylon. In the winter, it's going to cast quite a ways. One of the things I alluded to is if we look only at the extreme conditions, we're not looking at the in-between, okay? So I am really concerned that our current zoning our current language is weak, but you are correct. Now, it is not hard from a modeling standpoint with our 3D computer modeling capabilities. We know the path of the sun through the sky extremely well. We can map the surface of the earth in 3 dimensions extremely well these days. We can place on that 3D model each turbine, each house, every window of every house. And then we can throw in, what happens when the wind changes out of this direction, the sun shining out of here, where are those shadows going to fall? So this is a technological solution that already exists. But right now, our language in the current zoning ordinance does not call for that information to be used for either site planning or operational considerations. So if a wind project developer knows that, hey, we know that certain times of the year these particular properties can be affected by shadow flicker, then, okay, we know it's going to be attributable to these 2 or these 3 turbines. Therefore, when the conditions are right, we know we can turn those off. If the county zoning board builds into its regulations that not just what you have to do to get approval to build this, but what the negative impacts can be and must be avoided, what those negative impacts can be during operation, and then very clearly say you have to mitigate this, and it's going to be mitigated to a specific level. Then I think wind farm technology can be a good neighbor. I'm not anti-wind farm. I'm just I think what I'm opposed to is the language we currently have, which is, I believe, far too permissive to protect the safe and healthy enjoyment in the long term of many, many residential properties in what appears to be the next wind farm area to be considered in Champaign County.
So we need to be looking at the extremes, which, according to what you're suggesting, occur during the spring and fall.
Well, the extremes, thank you for following up. The extremes are mentioned in the ordinance, and those are considered summer and winter. But spring and fall, again, high sun angle in the summer, low sun angle in the winter. What about those intermediate sun angles? You see, I believe this particular language in the ordinance effectively makes it easy for the wind farm developer to produce a study that's easy to comply with. It's written, I believe that particular, it appears that particular paragraph is written to not necessarily directly benefit the developer, but it leaves the landowner, the people who are going to be living in this, leaves them high and dry with no recourse. See, it gets back to incompatible land use. If our ordinances allow something, and we've got unintended consequences, we need to make those unintended consequences right. I appreciate the other voices who have here this evening who have spoken of what other counties have done. I think really as a county zoning board, there really needs to be a study, a very due diligence study of what has been successful in other counties. Perhaps that's already going on, but I think that ought to be presented to the public to say, hey, we saw this, we saw this, we saw this. This didn't work so well for them. Hey, this worked for others. We don't have to, as a county, invent this. We don't have to reinvent the wheel. We're not plowing new ground. Let's use the experience of other people who have gone down this path before. I'm glad to hear that we have several contacts with those folks already. Does that answer your question?
Yes, thank you.
Okay. Thank you for asking.
Thank you, Mr. Ward. Any other questions from the board or staff? Yes, sir. So right now we have 1, 2, 3, 6, 7. So we have 7 more people, and the meeting will be ending at 9:30. So, Mr. Carter, Don Carter.
I will be the picture of Brett.
Can you say your name?
My name is Don Carter, and I live at 1799 County Road, 800 North, Philo, just down the road from Brad. My place is not as pretty as his, just awfully nice. As to relevance, the wind turbine heights, as they relate to the setbacks, is pretty much the whole ball game. So to me, that is the relevance. 18 years ago, I retired from enforcing the law in the city of Champaign, which I'm very happy to be where I'm at now. And with great joy, I moved southeast of Philo, and we have enjoyed our time there. Amazing. Now, there is a context to all of this, and it is not the riveting dialogue that typically happens at zoning meetings. We have a company by the name of Next Era Energy who is planning a wind farm in a 50,000 acre area south of Philo, Sydney, and Homer, and that's why we are here. They already have lease agreements in the hands of many landowners, so it isn't like they're just thinking about maybe we'd like to do this. And you are our champions. You are the ones that stand between us and people that many of us feel would ill-use that land out there. Incompatible land use to decent life without the proper setbacks and the proper regulations. You're all we've got. So we're here not to harass you. We are here to ask you to take up our case, take up our cause by passing responsible aspects of this ordinance that's before you. And we would like you to do that very much.
Any questions from the board? Any questions from staff? Thank you, Mr. Carter.
You're welcome.
Mr. McLean, Mark McLean.
I'll forfeit my time because I'd probably be just redundant, so move on.
Thank you, sir. Mr. Mistarver, Charlie Mistarver. Please take your name and address. And let's repeat this one, sir.
Charlie Starter, 1587 County Road, 300 North, Toledo. And actually, when Mr. Carter mentioned mentioned about Xterra. They sent me a letter, and they got my name right, so it's very unusual, and the install spelling it right. So I have great concerns about how they'll operate on a grand scale. Right? That's just, they're going to be picky. That's my nose right away. I almost threw away a thumbnail. Who spells something like that? Get my name right. So maybe that's a little bit about that. I appreciate you guys' time here. Yeah, most things I don't want to say, I think have already been said time and time again. I'm really worried about height. I'm even more concerned about the setbacks. These are an eyesore. I'm worried about property values and what's that do to the county, to revenue, if the taxes do it, or assessed values go down, which they should. Okay, what are we going to do then? Raise taxes, okay? Just going to cut for it somewhere. I cannot see the wind farm southeast of here, luckily. I have trees in my way. So my poor brother and my mom and dad have to stare at it every day, along with most people behind me. And it is an eyesore. And that's what almost in the next county. It's down Bellows County, right? It's pretty far south. Those things are 600 feet. They're enormous. It's like the size of the arch. Okay? And it's just an eyesore. But my other concerns, amongst those, it has to be really concerned with the mitigation of any kind of land problems that are in existence. The wind farm south of Champaign County, it's been there for a while now. The roads are crap. In fact, we're going to try to do some work on them, I think, this next week. Let them get good. Maybe we should all go down there and take a look at the roads in person. I'll send a picture. It's terrible. The road conditions are bad, field conditions are bad, there's broken tile lines everywhere. You all know, especially you guys behind me, as well as I do, you damage something in the field, you're never going to get back to where it was. Okay? It might get 80%, 90%, it might take decades, but you're never going to get back how it was. So that's a concern. This is, as many people already mentioned, very highly productive land. We shouldn't be taken out of production. Another concern, anybody ever talk to folks, some of these existing wind farms, a lot of the residences have had problems with groundwater, okay, well water. We aren't all luxurious, well view on a city pipeline of water, okay? A lot of us have well water. Some of these wells might be new, some might be 50 years old, some might be in jeopardy of having to be redug again, like we're doing drill. I know people personally, south of here, on that farm I'm talking about, they have water problems, but they've never resisted. And the houses have been there for 8 years, on the 8-year well, and on these wells. So let's think about that. I have a couple other things to say here. Mr. Hall, can I ask you a question, please? I'm wondering where your engineering degree came from.
I don't have an engineering degree.
Me neither, so we're on equal playing field. I want to know where that 699-foot height capacity you're recommending. Where does it come from?
It comes from a logic that I don't want to see the county having to bump up the allowable height for wind farms, nor do I want to see wind farm developers have to ask for waivers, given the risk. I think the county board should make a decision about what they're willing to allow and what they're not willing to allow, and leave it at that.
Okay, well, thank you. But help me understand, why not 701 feet? Why not 698 feet? I'm just curious. Is there any data to back that up? Or just a gut feeling? Because I definitely want to bottom it.
It's just a gut feeling.
Okay. I've got a feeling doing good and bad. All right. So you also mentioned, let's see here. You are not interested in stepping up height bounds, like you just referred to, right? You prefer to have something in place and not have to revisit that over and over again. Okay. Because, I quote, if I took my notes right, you don't know where the technology is going. I don't know where the technology is going either. But by that same token, that same logic, should we just put our speed limits at 95 miles an hour? Because at some point, airbags are going to get even better. We'll have more reliable vehicles. We should be safely able to travel at God knows what speed. Who knows what technology is going? So by that same logic, why do we have a speed limit? Something to think about. Another question. Has anybody done any investigation to see whether it's true or false farms that are in existence would be able to be self-sufficient without government tax breaks or subsidies? Is that going to last forever? And who pays that bill? We've already set our children and our grandchildren, folks that haven't even been born yet, okay? We've already saddled them with a huge national debt and state debt. Now we're going to say, hey, you're locked into this lease on this wind farm for 90 years plus. Is that fair? Talking about setbacks, I think Mr. Decker recommended 3/4 of a mile or something like that. 1 out of a mile. This is a great county set up in square miles. I'd be all for a 1 mile setback. And you did work with it.
Any questions from the board? The issue around the well water, do you have any other specific information as to what caused that, or?
I can only speculate, but I know that it wasn't like that before all the construction happened, and they're really close to one of the turbines. I could speculate, is there that vibration that we've heard about, right? Does that penetrate the ground? Does it cause settling? I don't know. All I know is that, cause and effect. So I have no scientific evidence for that. I just know that's been happening. This is something I've heard from more than one source, so I think it's worth considering, maybe finding out more. And I'd be happy to ask folks who know about it.
You know how deep the wells are down there?
Not fairly deep. Like 60 feet, maybe 80.
A lot of them in
The
the
wells
south.
go in.
A lot of them in the south end of the county, about
Some go really deep, some are like
Yeah, it depends
140,
where
some
you're
are
at.
200.
Mr. Starper, when you had stated about like the 1 mile setbacks, would that not take more farmland out of production than the?
No, actually, we're pretty much on square miles from most of this county. So pretty much eliminate the problem. That would be my reasoning for that. One thing I do want to mention too, if I can say one thing, when it comes to safety, they talk about well water, for example, safety. I actually helped a technician that was doing some wildlife surveys on a neighboring wind farm. It's been several years ago. And that day, we ran into a technician who was out doing a little bit of service, just routine service. So they had kind of on the tower, check bearings, check sensors, whatever they're doing, But they actually came from Wyoming, where they'd actually been working for several years at a large wind farm out there. I asked him, what's the craziest thing that's ever happened to you? He's like, well, I saw one of these blow apart one time. So there is blade failure. And I asked him, what was that like? He's like, well, I've never been shot at, I've never had a shot come at me, but I was really afraid of the third of that blade coming my way. It was half a mile away. And that wasn't the first one he experienced. So something to think about. I know, right? We kind of go with averages. There's a lot of probability you have to worry about, but how many problems is enough? Is one too little? One blade through a house, is that too little? One blade through a kid's bike, riding down the road to see grandma, is that too little? Might be. That's all I have.
Thank you. Mr. Beard, Justin Burkett. Please state your name and your address.
Justin Beard, 548 County Road, Illinois. From that address, I can visually see both the existing Champaign County wind farm at Penfield during the day and at night, and also, of course, the one just south of me, 5 miles in North County, that are 600 foot tall. So when we talk about this height increase, item number 2, I also farm in that Douglas County area adjacent to many of these windmills that are not on my property or property that I farm, but on neighboring ones. So from a setback requirement, when you talk about height, I really feel that the multiplier is not large enough. Having experience working underneath these 600-foot towers, and if you do use a multiplier to increase the height, it should not be a linear, where the X and Y axis go up evenly, it should be exponential as the height increases. And that, the purpose of that would be to reduce the shadow flicker. As they grow in height, the shadow flicker also falls farther, but you're also higher, so you're closer. Kind of like the moon being smaller, giving a full eclipse of the sun, when you think about it in those terms. So the shadow flicker is very annoying to work under. I can't imagine living under. So my concerns for setback are there. I really don't feel that the height increase is warranted at this time. I feel that the 500 foot has worked for this county. I really question the request of ELOC to change this zoning and put all of you, both in the zoning administration and on the zoning board. It's really a terrible position tonight. You have a lot of upset people here. I went back and I read the ELOC minutes from January and December when it was first talked about. It seems very unusual to tinker with something that isn't broken when current zoning seems to be working for Champaign County. So I question the motives of that. And I feel bad for all of you tonight because you're dealing with a lot of upset people because it's obviously a highly emotional issue. Moving on to item 3, the lighting mitigation. I think that is an excellent idea. I wish that Douglas County zoning, I wish Douglas County had zoning. And I wish they would have required that for wind farm, for that wind farm that's existing 5 miles south of my house. Because every night when I look out and I see those red lights, or when I work underneath them at night, it's highly aggravating and annoying. Makes you not want to be there. And if they were closer to my house, it would make me want to sell my house into. And we built a house that is our forever home, or so we thought. Maybe we'll have to reconsider that. I do question the lighting mitigation. While it would help, I would like more data on how much it would help being southeast of Willard Airport. Now, obviously, it's not a hugely busy airport, but there are a lot of private flights that come in and out, primarily private flights, not very many commercial flights, as we know. I don't know how many of those come in after dark, but we are in the ILS approach of the runways at Willard. So I think a study on how many flights there are might be worth the time. Again, it would help the situation. They would be off some, but is that percentage half the time? Is it 10% of the time? Is it 90% of the time? I have no idea. But I think that item should be considered. So again, I'm opposed to increasing the height. I think multiplier, if you do increase the height, should be greater, and it should be exponential and not linear. And for lighting mitigation. I'll take any questions.
Thank you, Mr. Cook. Any questions from the board or staff? Yes, sir. Mr. Nestor, please state your name and your address.
William Nestor, 250 County Road, 1600 East Helena. I just had a couple things. One, for, say, people live in town, I hear people complain about the railroad a lot. They're living next to a grain elevator, and I understand that's probably noisy and dirty or whatever, but that elevator railroad was there before the house was, or the town. So people knew that when they moved there. But our homes, they're there now, and there's no windmills, so that's my point on that. But also because of that, we farm southern Champaign County, and
those elevators to deliver grain to help feed America, help feed the world. So that's a must-have. What good is a windmill except to line the pockets of greedy people? That's all I got.
Thank you, sir. Any questions from the board or staff? Tracy Bosch.
My name is Tracy Bosch, and I live at 2265 County Road 300 North, Orleans. And if you would know, county zoning 300 North means I'm 3 miles away from Douglas County. That means I'm just 3.5 miles, 3 3/4 miles away from the Douglas County windmills. My son farms in Douglas County, and he just told me today, Mom, I'm tiling, I'm working on some tiling right next to the windmill. And do you know what it sounds like? Can any of you answer that question looking at me right now? Have you ever stood by a windmill? It's pretty quiet. I hear the birds chirping. It sounds like a blowtorch, non-stop blowtorch. I would recommend, before you guys make your decision, to drive out to the country. Can you even tell me where Broadlands, Illinois is? Can you tell me where? Can you?
Broadlands?
Yes.
Yeah.
Where? Actually, it's this way, sir. Anyhow, most of you probably have not drove out to the country. My sister lives around Royal, also around the windmills that you guys have approved and put in. I sit in her backyard, and yes, I see the flash. And someone asked earlier about what happens when these windmills blow apart. Maybe you should ask the residents in northern Champaign County what happens. I was told they blow all apart, and one of those blades went straight into the ground. So maybe you should ask questions before you make decisions. Maybe you should talk to the northern county, Champaign County northern residents, and ask how they feel about it. Maybe you should take some drives around Douglas County and look at their country roads. I just stepped down from supervisor of Raymond Township, so I think about roads a lot. And I don't want my roads to still be destroyed and looking like Douglas County. I now am the assessor of South Homer, Raymond, and Ayers Township. So my biggest concerns is the assessing and what these houses are going to sell for in 5 years. You guys are getting a lot of money up front right now, but what happens when these subsidies stop? What happens when you can't sell a house because there's a windmill in your backyard or your front yard? Your taxing assessments are going to go down. So in the long run, is this a big money maker? No, it's not. So our school districts are going to lose still. Our fire departments are going to lose still. Because you're not going to be bringing in money like you thought. My sister in Royal already has told me that that wind farm has sold 3 times. So what happens when the contracts are renewed over and over and over? When they promise these farmers, oh, we're going to pay you this much each month, what happens when the new contract comes out? That money's going to just keep decreasing. So they're making promises today, but what does that stand for in 25 years? We don't know. 5 years, we don't know. But I got to look out for the future of me, my fellow rural folks, that I hope that you guys are going to think about too. So I just ask for you to drive out to the country, sit next to a window, open your windows. I have, but sit and just listen and think about, do I want my house here? Do I want to sit and listen to this when I want to go home after work? Go home after work and I want to sit, enjoy some sunshine, but no, what am I seeing? A flash across my back porch, hearing this weird, high-pitched whirling noise like a blowtorch. I personally don't want that. And I would like for you guys to think about that before you make these decisions for us. Any questions?
Thank you very much. Any questions from the board?
spent a lot of time today, yesterday, all week writing these questions out. So just don't scan through them. Earlier, I saw a lot of you guys looking at phones. I saw a lot of you guys whispering to each other. I felt that was pretty inconsiderate because it's my life, it's my livelihood, and I didn't feel like that was very personal. I mean, I felt it was very not professional at all what you guys was doing to us because this is our life. This is concerning us and our future. So please think about that. Thank you.
Daniel Harriet, 30 Annapolis City, Illinois. So it was referenced earlier about DeKalb County. So DeKalb County, they were one of the first counties in Illinois to build wind turbines. They started back in 2009, and they referenced that they made their setbacks 6 times. So we're looking at other counties to consider. I would look at DeKalb County and make the setback 6 times from what the tower height is. I would also look at their zoning ordinance, and they have a 0 flicker on any of non-participating neighbors. We farmed some ground that was there in Douglas County, and whenever you're going back and forth in the field during harvest time, that flicker starts to get to you whenever you're just in the field. Now, granted, that never signed up for it, you had to tolerate it, but I cannot imagine sitting on the other side of the road in Champaign County and having that flicker hitting my house. Now, granted, again, Champaign County, Douglas County, you're on the line. But here, where they talk about wind farm, it's going to be solely in Champaign County, not close to the line. So I'd ask that we also look at and consider a 0 flicker for any neighbor that is not a part of the wind farm. If it's too restricted for any wind farm, they can always go to all the neighbors and ask them to sign some type of agreement, so that way they can have a flicker, they can build it to turbines where they want to. I would also ask that we continue with 500-foot limit on the wind turbines. We've got wind turbines here in Champaign County already. They're only at 500 feet, so why not just keep it where it's at already? There's obviously some company that can already build turbines in this county, so we should just keep that at 500. The other comment I'd like to make is I used to previously manage some land, and one of those folks that I managed land for, they own farm ground up in DeKalb County and Douglas County. They chose to have wind turbines put on their property in DeKalb County. When Douglas County farm came through, they said, no, thank you, we're not going to do this again. And they simply said no. They came back and said, hey, we really want your farm because we want to put a turbine on it, we want to cross through you, we want you to be part of the project. Again, they said no. So I think there's some merit to look at DeKalb County at the fact that they've been through this before, and now it looks like they're starting to ratchet up their zoning ordinance to consider all participants in the county, those that participated in the projects and did not participate in the projects. That is all.
Thank you very much. Any questions from the board? Thank you.
The next meeting is March 31st. In these cases, we continue to that meeting. Well, this case.
Do you have a motion to continue this case to the March 31st meeting?
So moved.
Thank you, Mr. Roberts. Do you have a second?
We're going to have public comment?
Thank you, Mr. Randall. Voice vote, all in favor, say aye. Opposed? Motion carries. Is there a staff report? No. Are there going to be any absences? Is there any audience participation with respect to matters other than the cases pending before the board?
Can't hear you.
Are there any audience participation?
Yes. John Crab.
One moment, sir. Do I have a motion to extend the meeting to 10:30 9:35. Or 9:35, sorry. Thank you, Mr. Ellis, Mr. Randall. Voice vote, all in favor, say aye. Opposed? Motion carries.
See you later.
Go ahead, sir.
I'm John Kraft. Just a couple observations. You need to get a better sound system. I can't believe it. County the size of Champaign has a sound system that sounds like it came out of a toy box or something. Whoever purchased this from did do a very good job. The other thing is, I find it offensive that you would continually interrupt people during their testimony to claim that, oh, this is not about a wind farm. Everything in that ordinance is about a wind farm. You don't think unlimited height has nothing to do with the proposed wind farm idea that you know nothing about? Everything, sound, flicker, setbacks, it all has to do with the wind farm. You sit there saying that has nothing to do with the wind farm. You know better. Do you think people are just going to think that, well, hey Bob, what do you want to do this week? Oh, let's change the ordinance to say unlimited height because nothing's going to happen. I think everybody knows there's a plan. Somebody knows there's a plan. Somebody gave the idea to increase the height, the maximum height, and that has to do with it wind farm, what you say doesn't know. That's all.
Thank you. My name is Kirk Allen. I spoke during the testimony phase, and ironically, I was before you don't answer questions. However, you answered multiple questions for other people. Very interesting. More interesting, I've attended probably in excess of 50, maybe 75 public hearings. Every public hearing I've ever been to, except this one, the purpose of the public hearing is for the public to get answers to the question and for the public body to get input from the public. And I say it's ironic with what I was told because in your own document, and I quote, if you would like to submit comments or questions before the meeting, please call the P&Z department and give the phone number and email address. What's the purpose of submitting a question? Anybody? Thank you. The purpose is to get an answer. And it's really ironic that we've got to the level that we can't even have a dialogue to address tough questions. I read through, and I don't know how much time I have, does this public body, have they adopted a public comment policy? Chairman? You guys have a public comment policy? I don't know. I don't know what my time limit is.
Yes.
You do? Could you tell me what the time limit is on your adopted public comment policy?
Until 9:30, or until we extend the meeting, for each meeting.
Okay, let me rephrase my question. What I'm looking for is the amount of time that a citizen speaks under public comment, how much time are they permitted to speak under the adopted policy that you have?
That I'm not certain.
Okay.
I know one thing, that we noticed that this meeting will end at 9:35 tonight, and for tonight, that will end public comment.
I would remind everyone, public comment is a First Amendment right. And I first spoke to what I found in the county code, and nobody was willing to raise their hands to have ever read the county code. For the purpose of promoting the public health, safety, morals, comfort, and general welfare, conserving the values of property throughout the county. That is the state statute. What I found really ironic is the mission statement provides clear and effective policies, plans, and programs related to land use and development to implement the county board's policies, blah, blah, blah. There's not a single mention about any of the required articles that are found in the public act for zoning under counties.
Mr. Allen, could I just offer that Champaign County has adopted a zoning ordinance that includes all of those good things that are in the Zoning Enabling Act, and these board members have read our zoning ordinance.
Are you answering for them?
Yes, I am.
Wow. You guys can't just say you've read the act. You say they have.
Well, I said they read the Champaign County zoning ordinance, not the Zoning Enabling Act.
Okay, my question,
Sir, what I'm not interested in is any gotchas or any type of like confrontation back and forth. Okay, we give up our time to do this, to be good stewards of what God has given us here in Champaign County.
and I appreciate that. All right, and part of being this is my public comment, sir.
Everything tonight
This is
has
my
been
public comment.
like attacking the board.
It was a simple question because I have to lay a foundation.
You asked the question, I'm answering the question, sir.
What question did you answer?
I'm answering the question of why we're here.
I didn't ask you why you're here. So what question are you answering? I wanted to lay a foundation because it's the most basic thing. I think Mr. Harkey said it. We need to get back to the basics. We need to start over. Because not one member has been able to say they've read the law, the actual law that you're bound by. And that is concerning. The public comment portion of this meeting is nothing more than a chance to be able to share input of people's concerns. My concerns are what I'm reading on the statute related to policy says nothing about what the law says. To me, that's a concern. When I ask if you have an adopted public comment policy, you say you do, but I guess I'll have to FOIA it to find out what it is because you don't know what the public comment policy is. You can't tell me how long I have to speak. I want to respect the policy you have adopted, but you can't tell me what it is. That's a problem. It's a problem from an aspect of where's the limits, and it's the same of you don't want limits for height. Well, what's your limits for public comment? You want to limit that, but you don't want to limit heights.
Now,
You're cutting me off. Is that what you're telling me?
it is 9:35.
Okay.
I do not have a motion to move past this time. Me personally, I don't think that we're going to be able to have this to come to a resolution tonight. And that's all the board has given me for timelines. So unfortunately, yes.
So you were cutting me off with my public comment time. Is that correct?
That is correct.
You're forbidding me to continue speaking, correct?
You can keep talking all night if you want, but we're going to go home. It's 9:35. You're already making motion to do that. This will be continued at the next meeting.
So does my public comment continue at the next meeting?
You yourself said that you have a First Amendment right to speak. I can't tell you no, but I can tell you that we're going to.
Okay, so you're cutting me off.
Do I have a motion? Thank you, Mr. Roberts. Do I have a second? Thank you, Mr. Reynolds.
You said adjourn or you recess it?
There's no wind.
There's a difference, gentlemen.